Greetings and welcome back to the third module of the ICWA Education Series, presented by the Nebraska Court Improvement Project in collaboration with the Nebraska Indian Child Welfare Coalition. Today we'll be discussing how to inquire with kids and families about ICWA eligibility and how we'll know when to apply the ICWA in our child welfare cases. The Bureau of Indian Affairs also includes a definition of when state agencies and state court stakeholders have a reason to know an Indian child is involved in their juvenile court cases. This is very clearly defined in the BIA regulations, and we'll be going over this in detail today. Both the federal and Nebraska ICWAs define an Indian child as any unmarried person under the age of 18 who is either 1, a member of a federally recognized tribe, or 2, is eligible for membership in a federally recognized tribe and is the biological child of a member of a federally recognized tribe. It's important to note that the parent and child do not have to be members of or eligible for membership in the same federally recognized tribe for the ICWAs to apply. Even more important is the fact that the ICWA is not a race-based law precisely because the law only applies to children who meet the definition of an Indian child as defined in the law. Identifying as Native American is not sufficient to invoke the protections of the ICWA in a child custody proceeding. In any case where a petition alleges the child is within the meaning of a 3A case or a petition to terminate parental rights is filed, the court must inquire as to whether any party knows or has a reason to know an Indian child is involved in the proceedings. According to the Nebraska ICWA, the Child Abuse and Neglect Hotline operated by Nebraska DHHS must also inquire with each individual caller whether they believe or know an Indian child is involved in the intake. Any suspected involvement of an Indian child must be documented on the intake, including the caller's response to the question and the names of any tribes the caller identified as possible affiliations for the child and family. Let's listen now to Alexis Zadejas, a citizen of the Omaha Tribe of Nebraska and the Child and Family Services and ICWA attorney for the Omaha Tribe. Alexis is a treasure trove of knowledge about the history of Indian law and attended law school with a specific desire to work with the ICWA and for her tribal nation. This goal was realized in October 2020 when she transitioned from Legal Aid of Nebraska's Native American program to work for her tribe.
I believe it's Antelope and Morton versus Mancari are the two primary cases from the United States Supreme Court that say that your status as an Indian person is a political status and not a race-based status. So ICWA doesn't violate any rights to the 14th Amendment or any other amendments wherein your equal protection rights would be violated. It is that way because of that federal trust relationship between the United States and Indian tribes. Indian tribes are sovereign nations under the United States. And so because of that, and I really hate this analogy, but it's in Supreme Court cases, so I feel like I've got to use it. It's that ward to child relationship. I really hate it. I don't think it's accurate. But because that's how the federal government sees tribes as sovereign, domestic dependent nations is what is used in the Marshall Trilogy. Because we're domestic dependent nations, we still have that. The federal government still has that obligation towards Indian tribes. And because of that obligation, we have certain political rights under our sovereignty and under that trust relationship. And those rights, especially because of the history of federal Indian policy in the United States, wherein we go through policy eras of assimilation and termination of Indian tribes and their political rights. This is a way that the federal government recognizes those inherent rights of sovereign Indian nations.
The The National Indian Child Welfare Association developed this basic flowchart to show the progression of how to determine whether the ICWA applies to your child welfare case. Whenever we use the term Indian child during these education modules, we mean the child has met the definition as stated within the laws, as shown here. It's not enough for a child or parent to identify as Native American or American Indian Alaska Native, because the ICWA is based on the political status of membership and citizenship in a federally recognized tribe and the United States. It's precisely this tribal nation to U.S. federal government relationship that Ms. Zendejas referred to in her interview. Now let's turn our attention to Misty Flowers as she talks about some of the different ways tribes determine their own membership criteria.
It gets really complicated, when you have a child that is of multiple tribes, and they could very well be eligible for membership with one or more tribes, based on, blood quantum requirements and whatnot.
A tribe doesn't have to utilize a blood quantum, though, is that correct?
That's correct. They can go off of lineage. There are several tribes that go off of lineage. And of course, we are the only race of people that has to track our blood quantum to show who we are, to prove, who we are. But
a construct of our federal government.
It's really important to remember that there are currently 574 federally recognized tribes that each have the ability to establish their own membership criteria as sovereign nations within the United States. When a child and family have any tribal affiliation, we must inquire with each tribe to know whether any tribe considers the child a member or eligible for membership. It may not be enough for you to ask about Native American heritage and tribal affiliations. You may also need to rely on previous information or interactions with the parties to decide if ICWA applies. As of December of 2016, when the binding BIA regulations went into effect, courts and state agencies are required to apply the ICWA in child custody proceedings whenever anyone has a reason to know an Indian child is involved in the case. Let's listen to some information from Amanda Doctor and Pat Caraher about reason to know, and then we'll review the actual definition as it is stated in the ICWA regulations.
We get a lot of questions from case managers and supervisors about applying the reason to know part of the statute. And it is new in our statute and in the federal regulations from the first time that ICWA was passed. So it's a newer element of the ICWA law. And I think it's one of those things where different legal parties and different stakeholders and the case managers, even nationwide, interpret reason to know a little bit differently. So we really try to work with our partners and our stakeholders and our legal team at DHHS to determine what Nebraska DHHS believes reason to know is, and how we have defined that is if a child is considered an Indian child, or we have reason to know that a child is an Indian child if their biological parent is enrolled with a tribe and that child might be eligible for a tribe. So we really just look that one generation back when we're trying to determine reason to know. If that family's Indian heritage is further back than one generation, we still try to work with those families. We just don't consider it an ICWA case under the strict definition of the statute.
In 2016, the Code of Federal Regulations were changed, and part of that change is that judges now have to make an inquiry at the beginning of every case to ask if anyone believes this is an Indian child, and I think courts have done a great job of that. But the other part of that is if anyone says, yes, I do think this is an Indian child, then the courts are supposed to apply ICWA right then and there, and the burden shifts to any other party to prove that ICWA does not apply. In the old days, the judges would say, I'm not going to apply ICWA until someone comes in here with proof, with evidence that shows that this child is an Indian child, as that term is defined by ICWA. And that was fine then, but since 2016, that's not the law. They're supposed to apply ICWA as soon as they have reason to know that a child is an Indian child.
As you have heard, knowing when we have a reason to know the ICWA applies in a case is not necessarily well understood. Let's review the BIA regulation about reason to know, and we'll step through the actual definition next. As Pat mentioned, judges are required to ask each participant in an emergency, voluntary, or involuntary child custody proceeding whether they know or have a reason to know the child involved is an Indian child per the definition of an Indian child in the law. If there is a reason to know, but the court doesn't have sufficient evidence at that moment, the court must, 1, confirm on the record that the agency or other party used due diligence to verify the child's membership status, and 2, treat the child as an Indian child unless and until it is determined on the record that the child doesn't meet the definition of an Indian child. The Bureau of Indian Affairs regulations define reason to know by stating that a court or state agency are deemed to reasonably know about the existence of an Indian child if a party, tribe, or agency provides information about the child's eligibility, the child gives the agency or court reason to believe he or she is an Indian child, the domicile or residence of the child, parents, or Indian custodian is known to be on an Indian reservation or in a predominantly Indian community, and an employee of the agency or an officer of the court involved in the proceeding has actual knowledge that the child may be an Indian child. Judge Amy Scheckman talked with us about reason to know from her perspective on the bench. Let's hear what she has to share.
At the very first hearing, I think there are 3 different answers that you can hear in court when we discuss ICWA. And of course, at every hearing, the very first hearing, the protective custody hearing, it's my job to inquire whether or not ICWA applies. And you can hear no, and then you move on. Or one answer could be, well, I don't know. I think maybe my great-grandma had some Indian blood, but I'm not sure. And they might not know the tribe, and there's a lot of confusion. In those cases, I'll find initially that it does not apply, but I'll order the department and the county attorney to send notice to the Bureau of Indian Affairs. And if that parent is able to identify a tribe, to send notice to that tribe as well. But usually in those situations, the parent doesn't have a lot of details and just knows that they themselves are not enrolled or eligible to be enrolled in a tribe. And the third situation is either it's immediately pled on the petition by the county attorney, or during the course of the trial, the department or the parent or the parent's attorney says at the very beginning that ICWA applies, that these are Indian children. And at that point, everything stops. So when we are told that the child is an Indian child, but we haven't heard back from the tribe yet, that can be a common situation. That sometimes the tribes don't always send a timely notice back, or sometimes we don't ever hear from the tribe, but the parent has provided evidence in the form of either testimony or an enrollment card that ICWA does apply. As long as we have sent out that notice to the tribe and the sufficient period of time has passed, then we can proceed. Hopefully the county attorney has made amendments to their petition, and we can proceed as if that child is an Indian child and ICWA does apply because the evidence has come from the parent. We don't always need to hear back from the tribe. More likely than not, at some point we will hear back from the tribe. They'll ask to intervene, or they'll send back proof that the child is an Indian child, but we don't need to hear from the tribe in order to proceed on ICWA and make the appropriate accommodations and services.
We hope this module has been helpful in understanding how and when to inquire whether ICWA applies to a child custody proceeding, which is early and often, as well as how to apply the reason to know provision in the BIA regulations. Next, we have some learning check questions specific to Module 3. We'll see you very soon in Module 4.